You may all be seated. This court is now in session. We call case number HSMB 01121, the Sheldon Museum Board of Trustees versus Marian Crabtree is now in session. Is the prosecution ready?
Yes.
Is the defense ready?
Yes.
We will now be allowing statements from the prosecutor.
All right. Ladies and gentlemen of the jury, I stand before you today with irrefutable evidence that the defendant, Marian Crabtree, entered a working place of work on the evening of December 1st, 2017, at approximately 4:30 p.m., where she then proceeded to steal the museum's Tlingit Blanket. A very valuable Tlingit Blanket, I might add, and then sold it for $10,000. Throughout this trial, I'll give you DNA evidence, video evidence, and an eyewitness. I'll also tell you how this woman had both the means and the motive to steal the blanket. It may be hard at first to believe that Miss Crabtree could do such a terrible thing and discard such a beautiful piece of culture. But don't let this fool you. She knew the worth of the blanket, and for her it was easy as taking it. Thank you.
Thank you, counsel. Would the defense like to give their opening statement now or defer until the prosecution rests their case?
I'll defer until the prosecution rests the case.
Very well then. Prosecution?
We would like to call Officer Bernard Towski to the stand.
If you'd like to stand and please. Which hand? Your right hand, please. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Then you may be seated.
Morning, officer. How are you this morning?
Good morning. Doing well, thank you.
Could you perhaps tell us what you saw when you entered the scene of the crime?
Yes, there was glass broken all over the place. The display case had been smashed. Like, basis.
Did you see any other evidence further into your investigation?
In the investigation, I did gather evidence. I found latent fingerprint on the glass of the display case.
And what about blood also found at the scene of the crime?
Yes, there was also blood.
And did you also see the surveillance footage with the defendant, Ms. Crabtree, on it?
I did.
Entering the scene of the crime?
Yes.
And what about this mysterious money that came into your account, $10,000, 2 days after that happened?
Yes, I received a tip from a bank employee about that unusual cash deposit was made 2 days after the theft.
And in your experience as a police officer, have you ever seen maybe a good person, perhaps like the defendant, commit crimes?
People are pushed to crime for all sorts of reasons, and regardless of their backgrounds, we look at the evidence at hand to determine whether or not people are guilty or innocent.
And that's all I have for you.
Thank you, counsel. Would the defense like to cross?
I would like to cross.
Maybe.
Sure. Officer Bernard Laskowski.
Laskowski.
Do you have a criminal record on?
No, she was an upstanding citizen. Worked at the museum as an established employee.
So she was a, okay, that's good information, but you have a criminal record on. So you're saying that you have no criminal record on her, but she still works at the museum?
Yes.
Was she seen on any of the video footage?
Let me review my own notes. One moment.
So, the evidence for Marian's arrest, did you say it was pretty solid evidence, or you say you're missing a few parts?
I'm confident in the evidence that we've gathered on Ms. Crabtree, both the latent fingerprints and her presence on the video camera.
Thank you, counsel. Does the prosecution have any more witnesses to call?
Yes, we would like to call Cordelia Johnson to stand.
Very well. Cordelia Johnson, please take the stand. Yes. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? You may sit down.
Ms. Johnson. So can you please walk us through what you saw around the time of the crime?
I was cleaning upstairs when I saw Mrs. Crabtree leave and go back. And I was downstairs cleaning the restrooms when she left and I saw her.
And do you personally know Ms. Johnson well enough?
Nope, I mean, I see her at work when I come in to clean, but that is usually it.
How would you describe her as a good person? Do you think maybe she'd ever be capable of committing a crime like this?
I honestly can't say. I do not know any personal information about her other than that she works at the museum. And I can't give an honest answer whether she will be there.
Has she been maybe acting odd of late?
I would say the demeanor and attitude that she had when she came with the bag was very odd for her. Other than that, I have no.
Okay.
Thank you, that's all we have. Thank you, counsel. Would the defense like to cross? You may begin.
So you saw Miss Crabtree enter and then leave the museum again, is that correct? Why did that stick out in my mind?
Because usually when I'm arriving, she leaves to go home and then she never comes back.
And you saw her carrying the bag.
Yeah.
Do you consider that suspicious?
Usually she has a backpack and the bag is not bigger than that.
Really? Because that bag is the same one that she always carries for when she's at work.
Well, it's different to me, but like I said, it was alright. Kind of bigger.
And when did you notice the blanket was missing?
I actually didn't. I cleaned her when not went home, sorry.
So you were the last person on the scene before the police stopped her?
I was downstairs.
Okay. Do you have keys to the museum display case?
Yes.
To the display case? Or just the museum?
Just museum.
No further questions?
Thank you, counsel. Would the prosecution like to redirect?
No.
Thank you, counsel. Would the defense like to recross? Cordelia Johnson, she may sit down. Thank you. Does the prosecution have any more witnesses to call?
Yes, we have multiple expert witnesses, specialists. We would like to call voice analysis specialist Morgan to the stand.
Look, please take the stand. Hands on that. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? You may sit down.
Could you please tell us what you found?
Yes, while listening to a recording of Ms. Johnson's testimony, I noticed a few things that caught my eye, my ears, I shall say. in the middle, when she was describing where she was and where the suspect was at the time, she paused for a total of 3 seconds, which indicates to me that maybe she had to take time to think. This shows that there could be signs of not full truth being told. The next thing that I noticed was she did tell me that she was upstairs vacuuming and then that she went down to clean the bathrooms. But when she says that the suspect comes back in, when she sees her after the peripheral visions, she says that she comes up and she sees her, but yet she's still downstairs vacuuming. So that caused concern to me. Was she upstairs or was she downstairs? Those are the few things that I noticed there. Her voice seemed rather steady, not broken. So I don't hear any stress in her voice when I heard the recording.
And could this possibly be just because she was maybe a little bit confused, being interrogated at the moment, asked all these questions?
Yes, it is normal for people to feel a bit of pressure when talking to an investigator or someone who might be asking them strange questions. But I would, with my expertise, I would know that when you're telling a story, for the most part, you know who you are, what you're talking about, and if she claims to have seen the suspect, she should know what.
But
he or
it's
she
possible
did.
for people to make mistakes.
It's very possible, yes.
That is all.
Thank you, counsel. Would the defense like to cross?
It's more even close. In your personal expertise, if you're telling the exact truth to an inspector or interrogator, would you feel so confident where you wouldn't make very many mistakes?
There are reasons for the brain to register certain nervous reactions when being interrogated, but if you're telling the full truth, you should know that who you were speaking of and who you are, and you should know where you were placed. But it is normal to feel nerves and to maybe make mistakes.
But you did say that she paused for 3 seconds between the time that she was upstairs. I mean, she was trying to figure out where the suspect was and where she was in the museum.
Yes.
Thank you, counsel. Would the prosecution like to redirect?
Yes.
Yes, we would.
You may begin.
Are you nervous right now? No, you're not. You're completely calm whatsoever.
Well, I won't say that this is my first time, but I am pretty confident in what I have to say.
You're pretty confident. And so then why did you just stutter?
That's a good question.
I'm definitely a man. And why did you call me ma'am? I do like
You look like a man, sir.
Thank you very much. So if you're completely calm whatsoever and you're still jumbling up words, would it make sense that the person you analyze would also mix up words, occasionally get thoughts confused?
Yes, this is a very possible thing, but it's things that I also want to note.
Of
But it is
course,
very
you still have to pay attention and know that is your job, but these things still can happen, and there isn't one rule for everyone, right?
Very.
So you're saying that even though our witness paused for 3 seconds and kind of got their words jumbled, she could be stumped, she could still be telling the truth.
Could be.
And that even though that your evidence says that maybe she had to think of where she was and she was going back and forth, that maybe it was just because she was nervous, because she was in a room alone with a police officer, having questions drilled into her, all right?
Yes.
Yes.
Are you asking if it's normal to be nervous? Is that what you're asking?
No further questions.
Thank you, counsel. Would the defense like to recross? You may begin.
So you are a professional voice analyst, is that correct? So you would know how to tell the difference between voice patterns that are common in people who are stressed, as opposed to people who are not. So would you say that Miss Cordelia Johnson's voice patterns were closer to those to someone who was nervous or to someone who was not telling the entire truth?
Her voice patterns seemed very regular throughout the entire recording that I heard, so I cannot say for sure whether she would be lying or nervous, because, like I said before, her voice was not shaky or higher pitched than normal, and so her voice did not show any signs of stress or anything.
She's not showing signs of stress. But she did hesitate when she was asked a question.
Yes.
Thank you, counsel. Does the prosecution have any more witnesses to call?
Yes. I'd like to call fibromyalgia specialist, Holly or Dylan. The same,
You
Dylan.
may sit down more close. Thank you. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may sit down.
Can you please tell us about this fiber that you found?
Well, we received a unknown fiber at the moment, and so we analyzed it first, just the fiber. And we noticed that it looked like goat fur. So then we took an impression of it and with cement, and we have come to the conclusion that it is mountain goat fur.
And show cap blankets are made out of goat fur.
I believe so.
Do you know where this goat fur was found?
No, I do not.
I'd like to state that goat fur was found on the defendant, Ms. Crabtree. Any other significant things that you found out about the goat fur?
No. It's like regular goat fur.
In your own personal opinion, or in your professional opinion, do you think it could go on the show cap blanket?
I think it's very highly possible, yes.
Thank you, that's all I have.
Thank you, counsel. Would the defense like to cross? May begin.
The fibers that were found on Miss Crabtree's scrubboard, could they have come off during, as part of her job, she handles the blanket daily. Could it have come off then?
That is possible, yes.
No further questions.
Thank you, counsel. Would the prosecution like to redirect?
No.
Mr. Hayes, you may take to the seats. Does the prosecution have any more witnesses?
Yes, we would like to call blood specialist to the stand, Tulsi or Zoe.
Zoe Hamilton, please take to the stand. Do you solemnly
Witnesses can
swear-
refer to what I got back here. I don't know if anybody wanted to see the goat fibers last time, but that happened. So,
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? You may take to this stand. Ms. Hamilton, can you please tell us about this blood you found?
So after me and my partner, Tulsi analyzed the blood, we came to the conclusion that it is AB negative, and it only occurs in 0.6% of the population. So if we were to have her tested and she comes out as AB negative, it would be pretty incriminating.
Any others significant things found out about this blood?
No.
Okay.
Counsel, would the defense like to cross?
So 0.6% of the population is taking that.
Yeah.
So the blood found on the carpet is likely Miss Crabtree's, since she is also a trans.
Yes.
But there are other differences about that blood type. So it is not, it is not 100% certain that it is hers.
That is correct. We would have to have her blood tested in order to make a direct match.
And there were no DNA tests that found the blood, is that correct?
Thank you, counsel. Would the prosecution like to redirect? Would the prosecution have any more witnesses?
Yes. I'd like to call our class specialists, Wendy or Louie.
Benassi, please take to the stand. Yes. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may take to the stand.
Ms. Benassi, could you please tell us what you found in your investigation?
Bears. Sorry.
Witnesses, you can always, direct the audience to the exhibits back here.
Yeah, so
If you want to.
key report, and then there's pictures of town. So on December 12th, 2017, at 10:45 a.m., investigator Lindsay Hill and myself examined a piece of glass from the broken sled case that was previously contained a Tlingit blanket that was stolen. The glass was examined, and it was concluded that the glass was most likely soda-lime glass, meaning that it didn't. When you break a tempered glass, it breaks into pieces, but they don't fall off. They break into little dice pieces, and clearly you can see that that object, or the glass that was hit, that big chunk broke into two pieces. And then after we examined it, the evidence was handed off to the fingerprint investigators for searching. Okay, and so I can't really tell where it was written, but we did examine it, and we do know that it was obviously hit on the outside, but it broke on this little piece, and it sharded off right there. You can see it's on the other side. And then we, on one of the pictures, we wrote down where the inside or the outside was, based on our analysis of the glass.
They were able to determine which side of this shard was the interior of the case.
Yeah. And I think it's written down on the bottom right there. I don't know if you can read that.
Yeah, it's written small in Sharpie somewhere.
Yeah.
In your investigation, were you able to determine maybe what broke this case?
Unfortunately, we weren't able to, only because we only had that small piece, and I just know that the kind of glass is not your usual tempered kind of glass. Because we know this because, like I said, had it been broken, had it been that kind of glass, it would have been broken into smaller pieces, and there would have been a lot more fractures, but this was just hit, and that chunk just like broke off.
Thank you.
Thank you, counsel. Would the defense like to cross?
So you said that when this piece of glass is broken off the box, the rest of the box would be intact in that case.
No. I just mean that if it's hit with a blunt object, as opposed to you having like a whole, like, okay, here's where you hit and it shatters, and the whole thing shatters. You hit it and pieces break off, and in this case, where it fractures, comes off, so here's the thing, and this is where it fractured, and here's the piece, and that's the piece that we obtained and examined.
So there's still a bunch of glasses.
I believe so. At least, that's the only kind of glass that we examined and obtained.
Was there blood on the glass?
No, there was not.
Was there, so if there was no blood whatsoever, was it anywhere on the box at all, or near this podium where the box was standing on?
That I am unable to answer. I don't really know the question to that. All I can tell you is that there was no blood found on the specimen that us glass examiners.
Now, if someone was to break the glass with their hand, would you say that it's a high possibility that they could cut?
Oh, yeah. Yeah, high possibility. Being on that piece of glass that we obtained, you might not see it depending on how far away that glass was from the place that it was hit previously. But like I said, there was no visible blood that we could find, and there was also no visible fingerprints.
Thank you, counsel. Would the prosecution like to redirect?
Yes, we would. So, you say that the defense says that the case was broken just by hand, right? That is what they just said, correct?
We didn't say that.
You
Speculation, Your Honor.
explicitly asked if the case was, if it was broke by the hand, then the hand would get cut. Is that not what you just asked?
I asked if there's blood in the glass.
Do you have the minutes?
No, we're not here. Nobody's there.
Where's our stenographer?
Do we have a stenographer?
I think that was Mr. Feeks.
Feeks, what do you think?
That was not the question.
Well, what was the question?
The question was, if it was broke by hand, would there be blood on it? Defense did not state that it was broke by hand,
I
nor
never
did
said
the
it,
witness.
I never said it, asking if they did state it was broke by hand. I asked if there was broke by hand, would there be blood on it, which you just confirmed. All right, if the defendant broke the glass with her hand, there would be blood on it, correct?
Yes.
If she broke it with her hand and she had a glove on, say a leather glove or another glove of that type, would there still be blood on it?
You know, it could depend,
If she had a thick workman's glove that she had access to, that were in the maintenance closet, that she had keys to, would there still be blood on it?
I would have to say that it would depend. Was she wearing a long sleeve shirt? Did she have it pulled up on all the way? If she were wearing this glove, did that glove completely cover her whole entire arm if it was bare? I mean, if you punch something, you are most likely going to punch all the way through, meaning if she did have a glove on and there wasn't any blood on her hand, she could still, from the shards, get cut on her arm. And I'm not so sure that she was wearing, or I'm not so sure what she was wearing, or even if she had a glove. I've never heard any about the glove being on the
So,
premises, so.
If you said if you punch the glass, you would punch all the way through, was there signs that the glass would punch all the way through, as you said?
No, there was
So-
no sign that
so
the
let's
glass
say-
was punched at all.
Let's say that the glass was hit by an object,
Okay,
and if that object didn't go all the way through, say it was a fist, so if that fist did not go all the way through the object, would there still be blood on it if there was wearing a glove?
okay, wait, say that again?
If you hit the glass with the fist and it doesn't go all the way through, it just stops right there. The glove is still protecting it on the fingers and the knuckles of the fist, correct? So would there still be blood from the fingers and the knuckles that are protected by the glove?
I would assume not so.
So you say
However-
that there could not be any blood even if the defendant broke out in the case?
I'm saying if she were to wear a glove,
Please answer yes or no.
say the question again.
You say that if you punch open the glass with a glove and it does not go all the way through, that there could still be no blood found on the glass.
Yes.
No further questions.
Thank you, counsel. Would the defense like to recross?
Can I make statements? Am I allowed to make?
No.
I was just gonna, I was.
Maybe begin.
So if the suspect was to break that glass, that box of glass, would she happen to get multiple cuts if she broke it with her hand?
I would assume so, yes, unless you are a super person and you can't get cut by breaking glass with your bare skin.
Now, what type of glass do you say this was again?
So, like I said, tempered glass, when it's hit with a blunt object, the entire thing will shatter into small little chunks. You can see all the little fractions or fractures. But with soda lime glass, when you hit it, certain chunks, big chunks, will fall off and break. So, like the fractures that you saw, it'll break. And a lot of the time, what will happen is it's so thick that little pieces will just shard and break halfway. So, for instance, if this were some glass, you can see on the other side that half of it, here's the whole glass, you can see the whole thickness of it, but then half of it sharded off, and so that's how we know that it was soda lime glass, because it didn't break in tiny little dice fracture pieces.
No further questions.
Shelley Benassi, you may take your seat.
Thank you, sir.
Does the prosecution have any more witnesses to call?
Yes, that was fingerprint specialist.
May Kamakana Kana Haley please take to the stand? Do you solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God? Thank you. You may take to the stand.
Tommy, first, if you need to.
Can you please explain to us what you found in your investigation?
So, as we were given the piece of glass, my partners, Aurora, Becca, and I were, as we were doing, as we were cleaning glass, we found fingerprints, but we found fingerprints on the outside and the inside, and 2 fingerprints from the outside matched Mary Apple Tree. Marian Crabtree. But there were another set of fingerprints on the outside that are unknown, or inside that are unknown.
Okay. So, Marian Crabtree, fingerprints on the broken glass.
On the outside.
Makes sense if you were trying to break the glass, I suppose. Can you tell which fingers they were?
Definitely.
A little bit blurred, this is outside here, these are the 3 lanes lifted from the outside surface of the display case.
There were, one of them was, this one, and index, that one, and then that's it.
These 3 piggies.
Thank you. Would the defense like to cross? You may begin.
Now, 3 fingerprints you said on the outside of Marianne's. That'd be a very regular part of her job to touch the outside of the bar. Yeah. But there's 2 unknown fingerprints on the inside. They did not match Marianne's. Now, there would only be one other person in the building at that time that was last on the scene. They could possibly have those fingerprints on the inside of that box that Marianne. Is that correct? So So now, if Ms. Crabtree, if Ms. Crabtree went in and left, and then if Cordelia Johnson was the last person on that scene before the police came, is it very possible that that could be her fingerprints on the side of the fence?
Yes, very much.
Are her fingerprints on record? Well, no further questions?
Thank you, Counsel. Would the prosecution like to reiterate?
Yes. Yes, we would. So, do you know if it's standard procedure when you bring in a witness to fingerprint them? And to input their fingerprints into the database? Yes, you do know. And is that true? So, would you like to restate your statement saying that that our witness, Cordelia Johnson's fingerprints are on file because she was called in as a witness? Yes, you would. All right. No further questions.
Thank you, Counsel. Would the defense like to recross?
Yes.
You may begin.
Now, since Cordelia Johnson's fingerprints are on file, did you bother to match the fingerprints on file to those fingerprints? Did not. So therefore, it's still a high possibility that that is Cordelia Johnson's fingerprints, since she was the last one on the scene.
Thank you, Counsel. Kamakana Haley, you may sit down. Would the prosecution have any more witnesses to call? Would like to call for recess?
We're allowed to do it. Already got cleared.
Very well says so. I will call for a recess that goes till 9:45.
Recess?
Yep, recess till 9:45. And I trust you not to expose anything about the case.
Out of order.
Okay. Okay, then I am going to, what is your objection?
I object because he's leading the witness and harassing him to words of his mouth. So that's my objection.
Then what's the word again?
Sustain.
Then I sustain. Yes.
So, let me reword this. So, was Ms. Johnson a witness that we called to the stand? Okay. So, if we call her up to the stand, what do we do when we have the witnesses come up? Like, what is the process to, in order to be a witness?
Place your hand on the Bible.
Before that. So if you had it fingerprinted on file and they did not match to any of them on file, never mind that. So if they're on file and you said that none of the other ones are to any match, could you say that Ms. Johnson's fingerprints were not found on the box? I'll take that. You said sure, everybody. No further questions.
Thank you, counsel. Would the defense like to recross?
Yes. Mr. Kamakana, now, before they go up to this witness stand, you fingerprint them, right? I mean, the witnesses, before they come up here, do you put the fingerprints on file? Is that correct? No.
I don't know.
Wait, you don't know, or is it no? No, okay, so that's a no. Wait a second.
For further clarification, are you talking about witnesses or are you talking about suspects?
Yeah.
Witnesses.
Expert witnesses, including these gentlemen?
Witnesses like Cordelia Johnson, who saw something at the crime scene.
Okay.
Would you put her fingerprints on file before she comes up here? No. No. So you would not put her fingerprints on file before she took this stand?
It was this mock Bible.
Okay, so if you're not sure about if you put her fingerprints on file before she took this stand, then when you're going through the fingerprints, you obviously have a high possibility that her fingerprints were on that display case instead of Marianne's, because you already confirmed that Marianne's fingerprints were not on the inside. That is correct. Is it not? Okay. So now, if you're not sure if Cordelia Johnson's fingerprints were on file or not, is that correct? You're not sure if they're on file or not? Or are you positive that they are not on file? Okay, let me rephrase this question. So,
The judge isn't even paying attention.
No, I'm paying attention.
were Cordelia Johnson's fingerprints on file or not? So you're not sure if her fingerprints are on file. So in that case, it's a high possibility that the fingerprints on the inside of the display case could be hers.
I object.
What's your objection?
We've already asked this question, and he's answered it.
I abstain.
Of course you do.
So is that a possibility? Yes or no? No further questions.
Thank you, counsel. Mr. Kamakana Kanahele, you may take your seat. Would the prosecution have any more witnesses to call to the stand?
Yes, we'd like to recall a glass specialist to the stand, Lindy.
Lindy Hill, please take the stand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated.
Your partner told us that if you were to break the case with your hand, you'd most likely get a cut and blood places. And in the briefing for everyone here, it says that she was examined and was found to have a small, single fine cut on her right forefinger consistent with her glass cut. And her blood matches a rare type of a single small spot on the carpet in front of the broken display case. So would this maybe help us to maybe understand that she did cut herself if she broke it with her hand? Also, I'd like to note that the defendant was seen bringing a bag back into the museum, so she might have brought the glass with her and left. Yeah. That's all I have.
Thank you, counsel. Would the defense like to cross?
Yes, I would.
You may begin.
Now, the blood found on the carpet below the case, would it be very possible that could be from a paper cup instead of smashing your hand into a case of glass? Because in the instance that you smashed your hand into a large case of glass, I imagine there'd be a lot more blood than just one drop.
Could be, but why would she have gotten a paper cut in our situation?
Well, let's say that she...
I object.
What's your objection?
The witness isn't a blood specialist, and he
Sustained.
Your last question is correct. So, could you imagine the amount of blood that would come off your glass from that box if she was to smash her hand into it?
There was
I
like
object.
blood on the glass and I.
What's
She's
your
not a
objection?
blood specialist.
Sustained. I request that we leave blood as a conversation.
No more. You wanna go?
Hey. I don't know, it's just that.
While you are not a blood specialist, you are familiar with some of the injuries that can occur as a result of glass breaking. So if someone were to break a glass display case, either with their bare hand or even with a blunt object, the shards of glass would likely cause cuts to their hand. Is that correct? Yeah. And there would likely be multiple cuts, not rather than the single cut that Ms. Crabtree has. Is that correct? Yes. No questions.
Thank you, counsel. Would the prosecution like to redirect? No. Very well then. Ms. Hill, you may take your seat. Would the prosecution have any more witnesses that they'd like to call?
We do. We'd like to call the defendant, Marian Crabtree, to the stand.
Very well then, Marian Crabtree, please take to the stand.
Yes, you do.
Put your right hand on the Bible. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may be seated.
Good morning, Ms. Crabtree.
I really couldn't agree with you on that.
I don't blame you. Could you explain why your blood was right in front of the broken display case?
I had a paper cut from earlier that morning, and I would assume that blood was from that cut.
You assume, but you can't be sure.
I cannot.
And why was it that you were seen leaving the museum, re-entering the museum, and then leaving it again, but with a bag this time?
Well, I always bring that bag to work. It is the bag I bring my lunch in. And I was at work as usual, and when my day ended, I went out to my car, and I realized that I had left my mittens in the museum. And it was a cold day, my car was covered in snow, and I did not want to go out there without my mittens. So I went back to the museum to fetch my mittens, and I came back with my mittens and my bag and left.
And what about this $10,000 that appeared in your account 2 days later?
My grandmother does not trust banks. She kept all of her savings under her mattress in cash. And she's a lovely lady, but she suffers from dementia. And she was not sure how much longer she would be able to go on keeping track of money. And so she gave me $10,000 as an inheritance.
It's odd, because I have it in the file saying that your grandmother's in good health and have no reason to give out money at this time.
I assure you she has dementia.
Alright. So, I'd like to confirm with you that your fingerprints were found on the case, your blood was found in front of the case, you have access to the museum, you got $10,000 2 days after the theft, and you've never got any other money except for around $2,000 and always in museum paychecks into your bank account. And there's also video footage of you leaving the museum, re-entering with a bag, and then leaving again.
There
Is this
not-
correct?
No, there is not video footage of me entering the museum, just exiting the museum and then re-entering with a bag. There is footage of me exiting the museum, entering without a bag, and then re-exiting with a bag.
Okay. Other questions on this fine?
Thank you, counsel. Would the defense like to cross? Thank you then. Ms. Crabtree, you may take to your seat. Thank you. We are beginning to run on the shorter end of time, and I'd like to ask if the prosecution has any more witnesses that they'd like to call.
Give the defenses.
Yes?
Can we bring Ms. Crabtree back up to the stand?
No.
Why not?
Because we are very short on time.
You'll have an opportunity to cross, but the
Yeah, you'll
defense
have.
needs to be able to present their argument.
Yes. Okay. So, defense, you may begin with your opening statement.
All right. Ladies and gentlemen of the jury, I will further explain the innocence of Marian Crabtree and how she was a responsible, hardworking person at that bank for over 5 years and goes to church and is the leader of the Girl Scouts. While Miss Cordelia Johnson has no background check, has been working there for a short period of time, and there is now a crime that's happened past 4:30 p.m. when she's a nighttime janitor. So all I ask of you is to make the correct decision in this case. And then let justice be justice.
Thank you. Would the defense have any witnesses that they'd like to call to the stand?
The defense would like to call Marian Crabtree.
Marian Crabtree, please rise to the stand.
So, on the night of the robbery, you left at 4:30 p.m., is that correct?
I left about an hour.
Okay. But you went back into the museum to grab your gloves and then you left.
Yes.
Your The blood on the carpeting was probably from a paper cut that you had gotten earlier. And the fingerprints on the glass and the wool fiber and the fibers found on your sweater could easily be from your job handling the blanket on a daily basis. So, how well do you know Miss Johnson, the cleaning employee?
I have no association with her other than that we work at the same place.
No further questions?
Thank you, counsel. Would the prosecution like to cross?
Yes.
You may
So,
begin.
they say they found a piece of fiber on your clothing. Why was that there?
If it was indeed goat fur, then it could have been because it is part of my job to clean out the exhibit cases, and I touch the blanket regularly as part of that.
Okay, so when you say regularly, how often do you say that you handle this piece?
I handle it whenever I'm cleaning, and I do that at least once a week.
Okay. So you say that you could have brushed up against it as you were cleaning?
No, I handle it regularly. I have to move it so that I can clean the case. I touch it.
Okay. So if you say you clean it regularly and handle it, wouldn't that devalue it and have it exposed to more oxygen and make the colors less vibrant?
Object, Your Honor.
What's your objection?
Speculation.
Sustained.
Wait.
You have to reword.
You can just say what you said again, but reword, please.
Okay. That was a big word, man. So, when you're cleaning the case and you handle it, wouldn't that have it more exposed to the elements other than in that case where the it's more maintained, as in like the temperature wise and how much oxygen and what the humidity and stuff like that? Wouldn't moving that so often devalue it and make it not as vibrant with color?
I honestly could not say. It's not my job to determine whether or not what I'm doing is right. It's my job to do what I've been told to do, which is to clean it in that way.
Okay. So when you say you leave and you say that you had to come back to get your mittens and your bag and then you leave again, therefore you say you have gloves in there. Now are these gloves thick enough to where if you were to break some glass, you would also get cut?
They're just knitted wool mittens. I do not know whether or not they would be strong enough for that.
So you don't know. So you're saying if you were to handle some sharp glass with those, you're saying that there's no way that you could be cut?
I do not know. I have never done it. I have no experience or expertise in such. I have no idea.
So,
Prosecution?
So, you say that you don't know, have no experience with the gloves in order to be cut. Now, if you think this, let's use some common sense here. Are they thick enough to the point to where if, I'm not saying that you've done it yourself, well, I am, but I'm not.
I object, Your Honor.
What's your objection?
Harassment of witness.
Denied.
Thank you, Your Honor. Anyways, back to what I was saying. So, if they're knitted and they're thick enough, you're saying you don't know, but is there a little possibility that if you think in common sense, you would break some glass, it could cut you through those gloves?
I really could not say.
Couldn't say. See, that's where I think you could, but we're gonna not go on that. Anyways, yes.
The prosecution is asking the witness to speculate on something that she has no reason to know.
Sustained.
Yeah, what she said. So, now, gallery.
You'll have to reword everything, or you'll just have to reword what you're saying.
Yeah, I think I got that. So, now, you say that you don't know, or you were not on the surveillance camera. Do you have access to the footage before the police did in order to say that?
I'm sorry, could you repeat the question?
So when they were asking you some questions, or somebody was, about the footage, and you said you were not on any of the footage, but leaving. So do you have regular access to the footage of the surveillance in order to make that statement truthful?
I'm sorry, are you asking me whether or not I was on the footage?
Yes.
There is footage of me, yes.
Okay, so, actually that really wasn't, but anyways, so how often Or how much access do you have to the footage?
That is not part of my job. I don't look at it.
Okay, so. No further questions.
Thank you, counsel. Would the defense like to redirect?
No.
Very well then. Marian Crabtree, you may take your seat. Would the defense have any other witnesses that they would like to call to the stand?
I'd like to call Hezekiah Finch.
Hezekiah Finch, please take to the stand. And on the button. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You may take to the stand.
Mr. Finch, how long has Marian been working for you?
Around 7 years.
7 years. Okay, would you say that she's a responsible employee of yours?
Yes.
Do you have any idea of her personality? You said, could you see her committing a crime like this?
No, I do not.
Now, on the other hand, Cordelia, how long has she been employed to you?
Couple of months.
A couple of months. And do you know, have you authorized a background check on her at all?
I have not done a background check on her.
But there is one on Marianne.
No. I do not perform background checks.
I'm not asking if you perform the background checks. I'm asking if you authorize the police to perform background checks.
There was no reason when I hired either of them to have a background check.
Seems like it is now.
I'd like to ask a question.
Was Crabtree a good employee?
Yes.
Is she a hard worker?
Yes.
Has there ever been any any reason why you would think she would steal something from the museum?
No.
And she has a great respect for the museum, is that correct?
Yes.
And for its collection?
Yes.
For the questions.
Thank you, counsel. Would the prosecution like to recross?
Yes.
You may begin.
Mr. Finch. Yes. Earlier in the day, did you happen to see this paper cut on Marian Crabtree?
No.
And Ms. Crabtree said that she, good worker, knows a lot about what she does. So she probably know how much that blanket's worth, correct?
She would, yes.
Do you perhaps have any clue as to how much the blanket is worth?
It's priceless, so it could go for anything at auction.
Even $10,000?
Probably more. I'd say most definitely more.
Thank you.
Thank you, counsel. Mr. Finch, you may take your seat. Thank you. Would the defense
Wait.
like to?
I was wanting to redirect, if that's possible.
Fair enough.
Mr. Finch, are you an examiner of fingers?
No.
Will you go up to somebody and realize a small paper cut on the bottom of their finger? If I have a chance.
No.
Unless she told you.
I would have no idea that she even had one.
Well, do you have any idea, I mean, So the blanket was priceless. So there's no amount of money that's really explainable to sell that blanket. I mean, how much? You couldn't put a price on it, right? Whatsoever. Do you believe that Marianne would know the value of this blanket?
Yes.
You do. And do you think that she would sell it less than it's worth? It was a priceless piece of material.
I believe that she would not sell it for less than she believes if she were to sell it. I do not believe that she would.
No further questions.
Thank you, counsel. Would the prosecution like to recount?
Yes, we would. So, as you stated previously, Marianne did know the price of this blanket, correct?
Yes.
And you said that it was priceless, correct?
Yes, it is.
So let's say hypothetically, that she did in fact take it, and she was trying to get rid of it quick. Is that something that she would be needing to do if she did in fact steal it?
I don't know. Did you search her house?
Yes, we did, and we found no evidence of the blanket being there. So we can assume that she got rid of it as soon as she got it. So if she did sell it, then would it make sense that she would sell it for less than it was worth to have it sell faster, and so to have the evidence in her possession for the least amount of time possible?
To Sheldon.
Would that make sense? Please answer yes or no.
I object.
What's your objection?
Being mean to witness.
Please answer yes or no.
Yes and no.
No further questions.
Would the defense like to redirect?
Excuse me, Your Honor, the fact that it was the defense's witness, they cannot redirect and talk to them for a third time.
Okay, well, thank you very much for the clarification. You may take to the seat. Would the defense like to call any more witnesses to the stand?
The defense would like to call Mavis McGillicuddy to the stand.
Mavis McGillicuddy, please take to the stand. I'd like to put your right hand on that Bible. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Please take the stand.
You're blind.
How do you know the defendant?
I know her. I know her through our knitting circle, actually, and we also attend church together. And I also know her through Girl Scouts.
And how would you describe her?
She's usually very quiet.
I object.
Excuse me, Your Honor. This witness is not on our witness list presented, and I would like to end this over. We have evidence from the Alaska Code of Court Law saying that if a witness is not presented on the witness list to the opposing counsel within 30 days, that witness's testimony is null and void.
I have
That was used with a highlighter, Your Honor. That's very unprofessional. I disagree.
We're in the court! I sustain.
Sustain?
Mavis McGillicuddy, would you please take the seat? Thank you. Would the defense like to call any more witnesses to the stand?
We'd like to call the blood analysis CSI people.
Tulsizano and Zoe Hamilton, please take to the stand. Swear you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please take to the stand. Thank you.
At the museum, there was a small blood spot on the carpet, yes?
There was.
Is that consistent with the paper cut?
It is, and it's also consistent with the small glass.
But if someone had broken the glass, you would expect there to be more blood, wouldn't you?
If they use their hand, yes.
Would they use a blunt object with their hand?
Like a small sharpie gun line that they could have got their hand from a distance.
Further questions?
Thank you, counsel. Would the prosecution like to cross?
Yes. So, in my briefing, or in the briefing of everyone involved in this, it says, her blood matches by a rare type to a single small spot on the carpet in front of the broken display case. And you said, if she used a blunt object, a piece of glass could have gone flying. I have, in Ms. Crabtree's bag, she has a blunt object, a thermos of tea that she could have used to break the case. Is that reasonable to, is that possible? Thank you.
Thank you, counsel. Would the defense like to redirect?
Yes. Now, you said that Marian had a blunt object like a thermos to break this, but now, since Cordelia Johnson's a janitor, she'd have a whole closet of blunt objects, is that correct? To break this glass, if possible.
Yes.
No more questions.
Counsel, would the prosecution like to recross?
Yes, we would.
You may begin.
And Marian Crabtree, being the assistant curator, would have access to the maintenance closet, correct?
I wouldn't know. I would assume so.
Well, I can tell you for a fact that she does have keys to the maintenance closet, which having the same access to all said blunt objects that the defense has brought up to use to break open the case. No further questions.
Thank you, counsel. Would the...
They can't.
Yeah, that was the third one.
Yeah, we can just call somebody else, I'm pretty sure.
Thank you. In that case, Zoe Hamilton and Joel Susano, you may take your seat. Would the defense like to bring any more witnesses to the stand?
We would like to bring the fiber analysis people.
Okay. Dylan Hayes, please take to the stand.
So, the hair that you found on Mrs. Marian's sweater, is that correct? You say it was goat hair?
Mountain goat.
Mountain goat. Are you absolutely positive it could be mountain goat? Could it also be from one of Marianne's 4 cats, William, Yogo, Felix, and Patrick?
There is no possible way it could be from a cat.
No further questions.
Would the prosecution like to... Thank you. Mr. Hayes, you may take your seat. Thank you. Would the defense like to call any more witnesses to the stand? Yes. Oh, before the jury, it's the closing statements, yes. In that case, we will take 3 minutes to give our prosecution and defense the time to prepare their closing statements. And the closing statement will start with the prosecution.
Second to spare.
We call case number HSMB 01121, the Sheldon Museum Board of Trustees versus Marian Crabtree, back into session. Prosecution, you may begin with your closing statement.
Ladies and gentlemen of the jury, you've seen here today unrefutable evidence of the guilt of Miss Marian Crabtree. You've seen goat fibers found on her clothing at the time of the arrest, matched to the blanket that was stolen and then sold for $10,000. You have also found that her blood was on the carpet right in front of the display case that was smashed by her thermos filled with tea, and the glass shattered, her being able to steal the blanket and walk out the door. You've also seen from an eyewitness and the security camera her entering without a bag and then exiting with a filled bag the same size as the blanket with gloves on her hands. So I ask you, ladies and gentlemen of the jury, to please make the right choice and find and condemn this Crabtree.
Thank you, counsel. Defense, you may begin your closing statement.
Ms. Crabtree is a respectable and responsible member of the community. Her employer does not believe that she would do such a thing. She has a completely clean record. She has never so much as gotten a traffic ticket in her life. She has worked at the museum for 5 years and nothing of this sort has happened. I find it difficult to believe that she would suddenly, out of the blue, decide to steal a valuable blanket and then sell it for less than it's worth. All of the evidence that we have is a video showing her entering and leaving the building, a blood stain on the carpet, and her fingerprints and nail fibers. All this serves to prove is that she was at work the day of the theft. Miss Cordelia Johnson has only worked here for 2 months. She has no background check. We have no idea what her criminal records may be. I think that she is, the vocal analysis has proved that she may not be telling the whole truth, and I think that she should be the one that one looked into for this crime. Also, Ms. Crabtree has the keys to the display case. She would not need to break the case in order to get to the document. Cordelia Johnson, however, would, but she only has keys to the museum.
Order. We will now see a 15-minute recess to allow the jury to be sent into their quarters. What?
Let's go 5.
Okay, we'll now see a 5-minute recess to see the jury go into their quarters to decide on the case. Chambers. There we go, chambers. I call back to order case number HSMB 01121, the Sheldon Museum Board of Trustees versus Marian Crabtree. I will now hear the jury's verdict on Marian Crabtree.
It's on its way.
It's on its way.
Right there.
Wow.
Oh, do I just bring it straight up to him?
Yep.
Do I have to do this like really official?
Yeah.
Brittany Bradford, please hand me the note. Would Marian Crabtree please take to the stand? In case number HSMB 01121, the Sheldon Museum Board of Trustees versus Marian Crabtree. Marian Crabtree is found guilty. Order in the court to theft in the second degree and a Class C felony. And because she robbed a $10,000 blanket that could also be called priceless, she will receive a $10,000 fine and 1 year of incarceration due to her clean record.
What happened here, good judge?
This evidence has just come to light, unfortunately, somewhat too late. On a second investigation of the scene, an officer of the Haines Police Department found this broom handle in the cleaning closet at the Sheldon Museum with a bloody patent fingerprint that does not match those of Marian Crabtree.
But
How
we
you
already
feeling now,
convicted
jury?
her. She's already convicted, we have to go through another trial, therefore she needs to be arrested.
Appeal.
No, don't. She's gonna be arrested.
I want an appeal.
So you appeal to the higher court because you feel there wasn't injustice during the trial, so you're appealing to the higher court.
She's still going to be arrested though? We just.
No, she's been convicted, so the bailiff would take her to jail.
You're the bailiff.
Yeah.
You said you're the bailiff.
Come on, man!
She was found guilty.
She was fine.
Sorry, Mr. Crabtree.
We can still celebrate.
Hey!
So they have to go to the higher
We didn't know that when we.
court.
How would you so much?
Injury on the job. It was also not a unanimous jury.
Yeah. Did you guys hear that?
We're done.
Wait, not unanimous.
So not everybody said that she was guilty.
Well, she's still guilty, man.
How was the vote?
The vote was 5-2.
So she was found guilty, and she would begin to serve her sentence until an appeal was made, right? And so her lawyers would get to visit her in jail, and they would bring a case as soon as they could to get her out of jail because it appears that she's been wrongly, accused, wrongly convicted, I should say. And then there'd be a new trial, right? So that would go, and it would be at a higher court, and the honorable judge would have had done his job.
Yeah.
Right. How did the vote go in the jury? Did you guys come to a consensus? What was the vote?
We have guilty, 5 guilty, aye, 2 not guilty, nay.
5-2 was the results.
So, Chief Scott, maybe you can answer this one. It's like, when does it matter if the jury has to have a unanimous decision, or when can the jury have a deciding factor, a vote like that?
You can have a hung jury with one.
Whoa. So
One opposed will hang a jury?
Yeah.
Okay, so this would have really been a hung jury.
Potentially. So before jurors go into the courtroom, and even preparatory aspects of being called up for jury duty, you're given a set of instructions. So they would have been disseminated from the court, a set of instructions, what you are to do and what you are responsible for, what the foreman of the jury is responsible for, and specifically what the defendant is being tried for, and the nature of the law and statute that she's being tried for. The great part about the courtroom is that it is steeped in religious and cultural history. Everything that you have before you, you are going to see in your lifetime. You are either going to sit on a jury once you start paying taxes. You are going to be a suspect in a crime.
Hopefully
You
not.
will be in a jury. You will be a victim. There is a high probability all of you will be within this process. Even going to traffic court, you will sit before a judge. When the whole truth, when you swear before the Bible and you say, will you tell the truth, the whole truth, and nothing but the truth? That's history. That's the French Code. That's based on, which is based on Judeo-Christian philosophy and law. There's a lot going on in this courtroom.
How did that survive the constitutional separation of church and state? How did that come through unscathed?
Well, if you look at the law of Moses,
Right.
there is an establishment for law that is steeped in mythology, then religion, then philosophy. But
that specifically, when you swear before a Bible or you swear an oath to tell the truth, it's that comes from France. It's something called the French Code. So our courtroom is multicultural. If you ever go into a courtroom in a federal courthouse, you're going to see Greek and Roman architecture. Lady Justice is blind, and she's wearing a toga. You know, I mean, you have to appreciate this. You represent what in history has been the crown. And now under our judicial system, you represent the state or the federal government, and you're supposed to be afforded those privileges. Now, in this court, you had a jury trial, but you can have a bench trial. So the bench trial would be where the judge executes the decision making. It's really, really interesting.
Would a Buddhist or a Muslim need to have put their hand on the Bible to?
It all depends. Sometimes they will. Sometimes when you're deposed or you're asked to swear the truth, some courts have established different procedures for that. I've never put my hand on a Bible, but I've been asked to swear the truth, and they'll ask me to stand and raise my right hand. And when I do that, I don't do this.
I have an interesting
I
fact.
stand erect, 90 degrees. I look at the court, and I affirm to tell the truth. The great part about, and you really have to have some perspective on this. This isn't sport. You represent a judge that sits before a bar. You have to follow a set of rules or they will take your license away.
Yeah.
You guys who represented lawyers represent that same bar. If you screw up, you falsify evidence, you do something that is unethical, they take away your license.
It's not the fog cutter bar you represent.
Right. Sure. Those subject matter experts typically are steeped in academia. If they screw up, they stop being subject matter experts. So all this stuff is steeped in a lot of process. There's a lot of things riding on this. We get caught up in it, these television programs, and I've been caught up even in court cases where I'm compelled to root for somebody. But it's more about doing things right and doing it within the process than it is about winning. What the defense in this case wanted to establish was reasonable doubt. What the state has to establish is factual evidence that the crime was committed and that the crime was committed by the perpetrator that they've set before you. So it's not, I talk about in law enforcement, this isn't a personal job. I have to live within the community that I enforce. I have friends and I enjoy the company of people that I have arrested before. It's one of the hardest things to do. The same thing is hard, likely for prosecutors and defense attorneys. You guys are going to be seen by that judge every day while you are employed. That judge is going to know you. That judge is going to know your habits because you see them every day. If you're a trial attorney and a defense attorney, that judge is going to see you. He's got book on both you guys. He knows your habits. So it ain't like this is the first time. So you have to do everything right all the time. It's really, really interesting if you get complex trials, especially trials that aren't, these made-for-television movies type things. Contract cases are really, really intellectually steep. Patent law cases are really, really complex. If you read some of the case law, one of the things about our industry is that our industry is dynamic. It changes all the time, and typically those changes occur because of constitutional challenges and or appellate court challenges. And that changes the way we do. Every year, we get opinions from the high court that may change aspects of our job. And it can happen just like that. It can happen because somebody does something bad. Like before, you guys all know what your Miranda rights are, right? Well, Miranda's a guy. He was a guy in Arizona that wasn't afforded his rights. And this happened in my uncles, my extended family are all either a lot of us are cops. We're either in the military or cops or farmers, right? You roll the dice and you pick one of three. So in all of my extended family's lifetime, they were law enforcement officers when it wasn't reasonable for them to explain Miranda to somebody, but this was a court case that was decided, and in my life, I have only known them. It's constantly changing, it's constantly evolving, and it's evolving because of what you did, what you saw, aspects of what you did. It's a constant ebb and flow of process, legal process, and it's based on people screwing up. It's based on people acknowledging the right thing to do. And, you know, it's something that should be taken seriously.
One of the
It's
things
a
that
lot
makes
of
the
fun.
country great.
And you guys showed a lot of enthusiasm. It's a lot of fun. When you go into that courtroom, you don't put your hands in your pockets, you don't wear a hat. You show the judge the respect that they deserve. And it's because of this deep-rooted process that lends itself to how we behave as, well, United States citizens and decent people. Make sense?
Thanks, Chief. Thanks for being here, everyone
Yeah,
who
no
came,
problem.
everyone who played a role, everyone who was in the audience, jurors, judge, everybody. I had a great time setting it up.
Thank you, counsel. Oh, yes, I would say so.
Yeah, so reset, if you're traveling, make sure you're